Well, good afternoon, everybody, and good afternoon, David. It's right at 1:30, so I think we'll go ahead and get started. Hello, all of our friends joining us. This must be a popular topic because we've had quite the response and number of people wanting to participate with us today. So welcome, and we'll do our best to do that. My name's Brandon Wright with Miller Tracy. And David Braun is joining us, and we're going to talk about all things SOPA. So how are you doing today, David?
Good. How about you?
Hey,
Long time no see.
I know, not too bad. I'm going to, for everybody's benefit, I'm posting a link to the PowerPoint in the chat box, so you all should have that now. So we'll post that a couple times as we go through today. And, because I know some people may join and leave, that you may close out that chat box, but we'll make sure it's there for us. Well, David, as we embark on this topic, one of the things that I think stands out to me in terms of kind of our approach for this afternoon is really to walk that careful balancing act, because I know that with a topic like this, where there's a lot to think about and certainly some work to do, that sometimes as attorneys present and talk about this topic, it can feel a little bit like we're trying to say the sky is falling or create work for ourselves. And I think that's certainly not our intent today at all. But I think we also have to recognize there are some steps here we're going to have to get for legal compliance. So our hope today, as David and I plan for today, is that we can walk away with some questions answered and some practical thoughts to say, I can do this, we're going to get this covered, this is not something to stress out about. But yet there are going to be things for us that we need to do and think about. I mean, thoughts on that as we kind of jump into this topic, David?
Yeah, I mean, one thing that occurred to me as we started talking about it is this doesn't necessarily, a lot of times we talk about creating a whole new class of potential plaintiffs. There are all these new people who are going to come at us. And the reality is there are a ton of laws that already protected biometric information. And in fact, there was just recently a case where the Illinois Supreme Court found against a defendant where school children had gone to defendant's side on the basis of biometric privacy data that wasn't appropriately stored or disclosed, or that we gotten appropriate permission from parents. Moreover, FERPA and the Children's Online Privacy Protection Act, COPPA, have existed in federal law for a very long time. So it's not that we're talking about a huge new class of potential plaintiffs. It's just that we have a bunch of tasks we got to do now. A number of things we got to put on our website, some contract changes we need to make, some other things that we need to be alert to, and probably some education for our staff. But they're really just check the box. We need to do these things at this point. And I don't want to oversell the risk of potential new plaintiffs. It's the same plaintiffs, just with perhaps a couple additional causes added through Illinois law, and therefore some things we need to do procedurally to protect ourselves from being easy targets on that.
Yeah, I mean, I think that so much of what we're going to talk about today overlaps plainly with those FERPA and student records requirements, as well as things that are otherwise already embedded in the law. I think we have some additional new notice requirements, certainly the web posting requirements that are there for us that we want to make sure that we're paying close attention to. And so a lot of what we're going to talk about as we're kind of being practical today is going to be checking lots of boxes at the same time, right? We're not only going to have our SOPA requirements met, but by doing so, we're also going to meet some of the requirements of FERPA or the Student Records Act, and also being aware of how those other privacy and confidentiality laws might require us to go even further. Well, we certainly already have a couple questions, some questions that we've received ahead of time, but we plan to start today, with the PowerPoint to kind of walk through and think through these issues, to kind of make sure we're all on the same page generally. So we don't want to spend too much time on that. And so I want to go through some of the basics that are here for us to make sure that we are all on the same page when it comes to some of these basic things. And I think this will help us answer some of those common questions that we're getting as we walk through it. And then we're just going to throw it open to questions. So as we go through the day-to-day, please don't be shy about asking questions either through the chat box or through the Q&A feature, because that's going to be our mechanism for interaction today. So please make sure that you're using the chat box for that. And again, a copy of the PowerPoint is linked there in the chat box. So we're going to talk through some of these things to try and get as practical as we can as we walk through your questions. And I think we want to start by talking about data privacy generally. This is a year, David, where I think all of us have come a lot further, a lot faster in terms of our use of technology because of the pandemic. And I think I've said multiple times throughout the year, thank goodness we didn't have full SOPA compliance yet, because that allowed us to have some more flexibility during the pandemic. But now is the perfect time to make sure we're getting our house in order in terms of our data privacy requirement, because so many people, especially as we're working remotely, are embarking on new technology and other things. We've got a lot of private data about students and employees that we need to make sure that we're taking care of, because hacking and ransomware and other efforts against school districts are certainly commonplace, relatively speaking.
Well, and I don't know about you, Brandon, but early in the pandemic, about this time last year, I know you and I were talking a whole bunch with each other about school districts that were using various platforms. And one thing I caught early on was a whole bunch of school districts that were using what amounted to public versions of software. Free Zoom accounts, regular Google accounts, not Google for Education, and those kinds of things, which weren't even FERPA compliant, let alone SOPA compliant. Now, the nice thing is, ironically, as a function of the pandemic, it is very rare that I talk to anyone anymore who doesn't understand what I mean when I say, make sure you're using the FERPA compliant version of Google. I get, in fact, I said that the other day, in fact, during the bargaining session, and I got kind of obviously, we all use Google for Education. We're not using the public version. But when I said that a year ago, there were crickets on the other end of the line. So I think, again, I think we're already doing a good job of starting down this path. That doesn't mean, one thing that I'm concerned about at this juncture is that we've gotten so used to we've sort of flip-flopped the other way, that we've gotten so used to some of our bigger contractors already being FERPA compliant, already being COPA compliant, already being biometric identifier compliant, that we've forgotten that some of our smaller contractors may not necessarily have good practices on that. Moreover, I think that one thing that we may see, maybe to an increasing degree in the next couple of years, is missing that opportunity with some of our contractors to talk about that degree to which we're sharing in the liability if something goes wrong. Because unfortunately, I know I've had, and I'm sure you've had as well, Brandon, a whole bunch of instances where these data breaches do become an issue. And it's impossible at that point to divvy up liability. At that point, the liability is what it is. Now is really the time for us to have that informed conversation about whose responsibility is whose, and that's where good contracting comes in.
And I think part of that is going beyond just basic SOPA compliance, but as you mentioned earlier, under FERPA, under our federal statutes, under the Illinois School Student Records Act, we've got multiple statutes that we all kind of need to come back with that. And so again, we've put some links here if you want to, there's some great resources out there on the federal statutes. Our intent today is not to go through that in great detail, but there are a lot of resources available out there at the federal level that we would encourage folks to take a look at, not only from the Department of Education's Student Privacy Office, but as well as, the private organizations like studentprivacypledge.org, where you've got software companies that, work and intend for K-12 use, where they're making sure that they're using appropriately compliant terms of service. and or using the Department of Ed's model terms of service. And I think that's really important for us. But we want to really jump in now to the very specific requirements that occur within our state law as it goes into effect July 1. So, we have, now the General Assembly did something friendly to us. They gave us almost 2 years, in fact, over 2 years to come into compliance. We just have all been busy for a lot of that interim time with other things that were pressing, like, a pandemic. But ultimately, they go into full effect July 1. And so we need to be ready for there. And again, a lot of those things are going to be relatively straightforward, but there are some things for our staff to do, our tech people to do, to make sure that we're getting compliant in terms of how we handle data privacy, how we use and enter into written agreements with those providers, and the regional security measures that we're putting in place, among other things. So, the ultimate goal there was to make sure that rights are known, that student data is protected, and that was ultimately the goal behind it. And so what we're really focused on for purposes of the statute is what's defined as covered information under the statute. Now, we can really get into, the weeds and the nuances of the definition for covered information that an operator, and we'll talk about that in a little bit as well, what that means. But I think broadly, we're talking about information or data that identifies a student, right? And certainly, while there's a lot more detail and nuance in that that definition, when we've got an online program or operator that that's going to have student information by which they can be identified, whether it's a software program, an app, a cloud-based program, those are things that are going to be covered. And I think that part of why I don't want to get too far in the weeds on the definition of covered information is, regardless of SOPA's definition, we have some of those other statutes, like the Student Records Act, like FERPA, that broadly also protects the confidentiality and privacy of student information. And so we need to be thinking about all of those kind of at the same time to make sure that our data privacy is not just SOPA compliant, but complying with all of those requirements and statutes.
Yeah, and I think this is a place where we as lawyers are operating at somewhat of a deficiency, because we get real lost in these narrow definitions and we try to exclude things. And I think that that's impractical, and I'm going to caution you against doing it, because I think if you start to try to dissect what is covered by SOPA and what isn't, you're going to be inclined to segregate data into two different parts and create two different sets of agreements and create two different sets of responsibilities, and frankly confuse yourself, which I think is just unnecessary. I think we presume that anything, just like historically, when I started at the firm, one of the first things another attorney told me was, forget the definitions. Assume that if somebody could figure out who the student was, that it's covered. And if they could figure out who the student was and it's covered, then it is your duty to protect and preserve it, period, end of discussion. Don't sit and try and figure out I was, as a young lawyer, trying to figure out the exceptions in the statute and understand them really narrowly. And he said, stop, you're wasting your time. And I think that's a great lesson for today under SOPA. I think that same rule applies. Assume that if somebody could figure out who the kid is, if the information is about an individual kid, not broadly about the student body, but about an individual kid, then it's potentially student identifiable information. It's potentially covered information. Therefore, it's covered under both the School Student Records Act, requiring us to treat it privately and protect it, and it's subject to this requirement under SOPA that we engage in those certain things that we're required to do.
Yeah, so let's get specifically into some of those pieces of the statute itself. A couple of the big picture pieces. Hopefully, some of those are pretty straightforward. We're prohibited from selling, renting, leasing, or trading covered information. Hopefully, we're not selling our student data anyway, because that would already violate, for example, FERPA or the Student Records Act. But that prohibition is clear. And it also requires us to have a written agreement to share covered information with anybody who is not a student's parent, school personnel, or certain state and local officials. And so we want to make sure that we understand those requirements, as well as we have to have information on our websites about how we collect, use, and disclose that covered information, and that those explanations are written in a way that are understandable to a lay person. Those requirements are there, as well as having procedures on the website of what those rights are under the statute, what we call those Section 33 rights, a list of operators and subcontractors, and a list of covered information violations by the school. And so we have to really have an idea of who those operators are and their subcontractors, because we're going to have to post those, as well as copies or links to those written agreements with those operators on our website.
And we've got to update it every no later than 30 days following the start of the fiscal year and no later than 30 days after the beginning of the calendar year. In other words, we've got to continually update not only our website, but also we've got to pay attention to our contracts and make sure that we have contracts with these operators that are holding, storing, collecting our student data. And one thing that I think is really important here is, in order to disclose those things on our websites, disclose all the contractors, have links out or information on our website as to how they use that data, collect, use, and distribute that data, is we have to understand that ourselves, or at least know where to find that so that we can copy that in. And I think that's one place where we, as school officials, as school service organizations, I think we've kind of had a blind eye to that for a long time. That we just kind of use these things because they make our lives easier, and then we just don't worry about the way the data is collected, used, distributed, et cetera. And I think it's important. Look, I don't think there's any school district selling data for schools, or at least for their students, or at least I hope there isn't. But I'm aware of lots of contractors that are seeking to collect that data in order to use it for sale. And therefore, it's important that we have an agreement that we can point to that says this is where they're specifically prohibited from doing that. I also think that there's at least some risk under SOPA that if we don't think before we distribute information, when we get those blanket requests for information for sale, there's at least a potential for a new cause of action if we provide that data without having thought about whether we really can pursuant to these new restrictions.
Yeah, and we also have a list of those any violations, data breaches, really from July 1 forward. So we don't have to put those that are if involve less than 10% of the population or happen prior to July 1, then that is not required to there. And as David mentioned, we've got to regularly update those things on the website. A question here about the website: does this apply to special ed cooperatives? I think SOPA does apply to special ed cooperatives by virtue of the definitions within the statute. So I think that yes, special ed co-ops, you get to play this game with us too. You don't get out of it. There's also an important policy piece here. So we've got to have a school policy that designates which employees are allowed to enter into those written agreements with operators. And those written agreements then, of course, get to the website as well within 10 business days after entering into them. I would just point out in the most recent press update, there's a new policy 7345 with administrative procedures to that. So I know most districts are press policy subscribers, and so make sure you're getting all of those pieces ironed out as you're hopefully getting those press policies updated and finalized well before we get to July 1.
And don't forget to fill in those blanks, particularly now there's the ability to have, not requirement, but you may have a privacy officer for purposes of SOPA compliance. If you're going to fill in that blank, you're going to put that person in, make sure you actually do it. You shouldn't say our privacy compliance officer is blank and then not fill in the blank, because that's an easy way to confer liability on a school district that you were deliberately indifferent to what it was that you were doing.
I got a couple questions here. I think that's policy 7345. 7345. So I had a couple people jump up and ask me to repeat that. So I think that's the the policy number. We're also required to ask an operator to delete covered information if a parent or student asks that it be deleted, unless that would otherwise violate the law. And of course, the other key piece here is that we've got to make sure that we are putting in place reasonable security procedures with our own staff, as well as with any third party with whom we share information, that they are using those same reasonable security procedures that are to be defined. And if you want to know what those should be or are, the Illinois LTC, the Learning Technology Center, has put together a list of 43 reasonable security practices that you can download from their website and go through what you think those things need to be. You know, our intent today is not to read those to you, but I think these are really important for those who are training and putting in place your tech view to know what those requirements are.
And I want to identify too that those, now is the time to pull those and take a look at them. They're really good. Some of them are really broad for all of your, excuse me, really good and broad for all of your employees. But it's also important to know that some of those are pretty deep in the weeds of technology directors. So if you operate a very, very small school district and you kind of do everything yourself, make sure you're taking a look at those now and asking yourself, do I have the capacity to assure that all these things are accurate and we're doing these things the way we're supposed to be doing them? And if we aren't doing them that way, do we need to hire somebody to come in and at least do an audit, at least take a look at what we're doing and make sure that we are compliant with those? Because some of those have very narrow technical requirements. I mean, in our own firm's website, we've had challenges with some of those things and have talked ourselves about what our technology requirements are, and have upped those pretty dramatically in the last few, really in the last few months. We've upped those dramatically to assure that we remain compliant. Because remember, this stuff changes often, and I do notice here in the chat that ISB has endorsed LCC's practices, and it's actually on their website now. So if you go to isb.net/pages educational-technology, so if you Google ISB educational technology, you'll find those there as well.
I'll pop that link in the chat box as well.
Cool. And I see a question here that goes to I think the next slide. Do we have to have a privacy compliance officer, or is this just optional? And I want to segregate that into two pieces, because it is a may under the statute, but you have to designate under the policy who has authority to enter into those contracts. So those are two separate pieces. I would tell you, at least in my humble opinion, and Brandon, if you disagree, by all means, but I don't think it's a bad thing to have a privacy compliance officer, if only because, particularly if you were in a larger district, kind of going the other direction, it's good to have somebody who's responsible for watching these things. It's good to have somebody, of course, that you can hold accountable to make sure that you're keeping up with what changes. But it's also good, I think, to have somebody who's an expert on these kinds of things and watching the things coming in, and who's taking responsibility when the requests are coming in. And if we have a breach, to make sure that they know what those Section 33 rights are, and making sure that they've got those procedures up and keep that website updated. There is actually a lot of stuff here that comes up annually, actually biannually, that comes up twice a year that you have to keep watching. And I think it's beneficial to have somebody who's held responsible for that.
Yeah, I agree. I mean, my view is if no one is in charge, then no one is in charge, and it's not going to get done. And so I'll share later my tip about making sure that we don't have a one-person show, but at the same time, I think it's important that we are designating that responsibility so that within the operation of our school district and the operation of our organization, we've got the people in place who understand what their responsibilities are specifically. And again, this also applies to operators as well as to the State Board of Education. And we have those student and parent rights in Section 33 that we've got to post. So let's get to some of our compliance issues, again, as we walk through what we need to be doing. So what should we be doing now to comply Well, these are some things that I think we need to start with. And we've got to start with making sure we're putting in place that we are implementing those reasonable security measures. And so now that we've got, these requirements that are in place, we want to make sure that we are meeting or exceeding that standard. And that goes back to, those security practices that were recommended by the LTC that now ISB has endorsed, that I think is there for us. And so I think it's really important that we are walking through that. Now, a list of 43, some of those are pretty big items, right? I mean, I'm not going to sit here and read those to you, but I think some of the really key pieces to that include some very fundamental things like taking an inventory of what you've got and what you're using, both from a hardware and a software standpoint, that there's some training aspects that need to be in place. I think that's an important piece that we've got to go to. And so we just want to make sure that we understand that. Some of these are bigger things like training. Some of these are really specific things like how we have things set that your tech folks are going to understand and that are going to be important for them to do. So that's where we've got to start with those reasonable security measures. One of the things I always when I talk about this, David, is I think about who is least likely to maintain that, or maybe I should say it the other way, who's most likely to create a security issue for us, right? Who's going to be the person who is clicking on a phishing email or opening the wrong thing or downloading apps that aren't supposed to work? We need to make sure that we're really targeting those folks to help them make sure that they're doing what we need to do in terms of those reasonable security measures.
Yeah, and one thing that, I mean, again, to our own experience within our firm, one thing that's been really helpful is everybody having an idea what the software actually can do and is supposed to do. And to the extent that, one thing we learned early on, just in our own firm, is that we had a computer that got infiltrated 1 million years ago, simply by somebody doing something really, really ordinary, not some of the crazier stuff we have to do where we go searching through things that somebody has done to try to understand the case that we're about to have. We literally just had somebody click on a very ordinary link in a news story, not having any idea. Now, fortunately, that computer had been walled off from any data. That was something that we did a long time ago, was wall that off from any of the data that we keep. But it became apparent to us at that point that we needed to have discussions with everybody about where you could click and where you can't click, because we kind of assumed everybody understood the same thing, and not all of us did. Like myself included. I mean, I'd be first to take the dive on that one. There were all kinds of things I didn't realize were transparent. And so you do need to actually have conversations about that, but there's also software out there that can help you reduce some of those clicks. Not to upset my brother who's in advertising, but there's blocking software that you can utilize on a web browser that will reduce some of that infiltration. There is, obviously, we've all got SIPA filters, and those SIPA filters, Child Internet Protection Act filter, and those SIPA filters can really dramatically cut down on the number of potential breaches. But again, you have to understand what your software can do, and then make sure that you're building your practices and policies and trainings around what it can do, what it should do, and what it must not do.
Sure. I think the next thing is making sure we're getting those operators in compliance. So that starts with making a list. We got to know what we have, right? And then from there, we want to make sure that we are working with them. I mean, some of the big hitters who we are, the frequent flyers like the IEP software programs and other student information systems that are used, they, a lot of them understand this and are taking efforts in that regard, and had conversations with lots of those different vendors, but there are others who may not be. And we want to make sure that we understand where we're at and that they understand where we're at.
And one thing that I've already run into here is be really careful as you're going about this, as you're walking down this path with your contractors, that you have some adequate understanding of who you're working with. There's a big difference between a company like Google and a company like Teacheries and a company like the local software company down the street that's providing sort of a localized solution for a narrow set of problems. Your bargaining power is very different. And actually, I was working on a teacherese agreement earlier, and I read this on their website that I thought was really, really useful. It says, Illinois SOPA compliance. We've long followed the spirit of SOPA. We've been handling confidential student data for many years, and it's essential to our businesses to effectively protect it. The new act reiterates many restrictions, and I'll tell you, I was already excited to see they understood the new act was there and that they were trying to comply with it. The new act reiterates many restrictions enacted by FERPA and the Children's Online Privacy Protection Act, COPA. As mentioned above, to become fully compliant with SOPA, we have updated our terms of service, but here's the catch line. Some customers have reached out to us with supplemental agreements, which made sense prior to our terms of service update. Given the changes, we believe external agreements are unnecessary. We like to be cooperative with our customers, so we're not philosophically opposed to SOPA agreements, even when unnecessary. We will be happy to review, respond to, and assign the reasonable ones. We would temper expectations, however. Some agreements go well beyond SOPA requirements and are more of a software buyer's terms of service wish list. We'll probably push back on aggressive contract terms, especially if it would negatively affect our internal operations. One thing I've seen in a lot of trade organization agreements that have been sent to me, I've seen several wonderful agreements, very well written. And if I were the attorney who'd written them on behalf of my clients, I'd be patting myself on the back because they're excellent for you folks. But the problem is that when you send that agreement to Google, Google's going to go, you're going to get no positive movement on that. Because it's Google, they're enormous. And if they agree to hold harmless language on every breach in every little school district across the country, I mean, it's probably not going to bankrupt Google, but they're the big fish here. They're the big hitter. No one contract matters that much to them. Teacherese is quite a bit smaller than Google, and so you're probably going to have better luck with Teacherese. But even there, they're telling you they're going to push back if it's really aggressively in favor. So I want you to temper your expectations when you get these trade organization agreements, which again, I'm not discouraging you from using them. They're wonderful. They're very well written. I've read several. I have no objection to them in many instances, but be careful to temper your expectations when you're working with big companies. This is not necessarily a one-stop shop, it'll solve all your problems agreement. It's a good place to start to understand what the issues are. But I think that it's also a much better utilization of that time and that tool to start to talk with your contractors about how we're going to share that liability in the event of a breach. What are each of our responsibilities going to be in the event of a breach, and how are we going to manage that?
Yeah, so we've got to get there. We've got to get that list. We've got to get those links ready to go. The next item here is we've got to figure out who's going to be permitted to enter into these written agreements, and that's going to come back to the policy piece. So we want to make sure that we're getting those policy pieces in place so that we are meeting our compliance with that as well. And then this is going to require then putting those procedures into place. You know, I think that's an important factor as well. We need to be prepared for what we're going to do in the event of a data breach. So don't wait until you have a data breach to figure out what are we going to do. Let's create a form and a process on our checklist now so that when we get to that point, we are ready to move forward, because now there are some specific timelines in place. I mean, frankly, I think that the required notice under SOPA is consistent with what we've had under the federal level before, what's been recommended by the FTC already, but now there's a timing of 30 days associated with that. So we want to be ready to go to have that out as well. We want to be thinking about data redaction so that we're not using data more than we need to, right? So that we don't want to put stuff into out there into the world with student information that we don't necessarily need to, right? So let's think about how we can redact data so that we don't need to use student data in ways that we don't need to. And if there are ways that we can mask data to protect student privacy, I think that's something worth considering.
Yeah, and again, a software piece that we've got to be careful that we understand how our software works.
Absolutely.
And what it can, what it can't. And also, I mean, just from an educational standpoint with our teachers and our staff, thinking about when we're using student data. I can't tell you how many times I've been standing in the grocery store and an email comes in and I instinctively swipe down and click to see what's going on in that email. It's something that we've got to start to re-educate ourselves about. Something. Now, it seems crazy at the present moment that somebody might be standing and looking over your shoulder. But before about a year ago, that was a pretty common reality, is standing in a grocery store line, somebody might look over your shoulder. And again, not that that's likely to create a breach in a lawsuit and yada, yada, but it could. If somebody happens to see something in a smaller community and the rumor spreads, that's how we end up with potential liability. Bad facts make bad law.
And then, of course, those agreements, which David certainly has talked about already. So before we get and throw it open to Q&A, we've got some great questions. So hang in there. We're almost to the point of jumping to the Q&A. I just want to walk to some of these key reminders here to put in place to make sure that these are things that we are actively thinking about from that not only SOPA compliance perspective, but that bigger picture. And one, choosing the right platforms, making sure that we're not using the free Gmail account, that we're not using the basic version of Zoom that doesn't have the privacy protections, whatever else we're talking about. The choice of platform is 99% of getting there.
I agree. Understanding what it is you're using and not trying. This is not going to be a very good moment in time for us to, pardon my saying, cheat out on various pieces of software or use what's easy. We're going to need to spend the appropriate amount given what we are. We're an enormous liability target. And I think this is a good moment in time to be using a professional Zoom account, to be using our Google accounts for education, for using, there's a question here about Facebook to share certain information. I certainly wouldn't be using Facebook to share covered information, that is information that is student identifiable information. I wouldn't be using Facebook for that purpose. Now, to use it to share information about when an event might occur, that's, to my mind, that's perfectly okay. That's not student identifiable information. But if it's student identifiable information, I don't want to be using Facebook. I don't want to be using Twitter. I don't want to be using these other companies that frankly are fairly well known for historical security breaches. We right. want to use something keeps in mind what we do.
Number two here, make sure that we all understand that we actually enforce our acceptable use policy and procedure. Now, let me just quiz you all. When's the last time any of you actually read the acceptable use policy and procedure? And you probably have every student and every employee sign off on it every single year. But when's the last time you actually read it? Let alone enforced all the things that said, here's what we're going to do. Because I think that's where sometimes these breaches and security, because we start using the school district's network and systems and devices for purposes that go outside what it's intended for. And so we want to make sure that we are using it for its intended purpose, not for personal use unrelated to school. That is oftentimes where those security issues pop up.
Mm-hmm.
And this might be the key to it all, having a clear, making sure everybody clearly understands the process, and written policy is required now for what apps and software are appropriate and secure. I mean, it's answering the question, who can download what and when? And this might be one of the most important things that we do between now and July 1. And then there's a huge sort of training and expectations component for that for staff. Because if we've had a practice where anybody can download any app they think might be cool, I'm going to download this game on the school's iPad as a reward for students because it's fun to play and it seems appropriate. But did we know that when we click yes to downloading that game, it said that that game can access the data in other apps on that same device, and now they're accessing maybe covered student information because the game is free? I mean, those are things we need to be prepared for.
Well, and again, I mean, this is something that, I mean, internally, we've had this discussion for a long time, that Windows has a two-step process, particularly if you have Windows Professional, there's an administrator password. Make use of that if you're not already doing that. It's, for some of you, it may seem very basic, and for some of you, it may sound like way more than you're already doing. I'd strongly suggest using that two-step process so that people are looking. Nobody's downloading anything to the computer without two people looking at it to be sure that this is software that isn't going to compromise the totality of security. Isolating those computers from where their data is stored, that's tremendously important. I mean, even our phones these days, we have to be very careful that if we're accessing information that my wife works for the university, and on her phone, she's got a separate security protocol that isolates anytime she's checking her email from literally anything else. She cannot check that email, can't, even if she downloaded a program, it would download only within that software, and it couldn't look at the rest of her phone, because she, again, is dealing with student data. And yes, they need her to have access to it on her phone, but it can't have access to everything else. And so it's really important that we're thinking, same thing with the iPads. The iPad, we may think that the iPad is secure because that's a locked environment. Apple controls that environment really seriously, but it's not a perfectly secure environment, because many of those apps, including Apple's own apps themselves, seek access to data throughout the device. And so again, having a limit on what it is that those devices can access. And again, if you don't have a tech person, your tech company or a subcontractor can set those automatically default to reject certain application permissions to get access to other things. And now is a great time to start having those discussions.
Yeah, and so number 4 here on that top 10 list is making sure we're maintaining that security when we're using our personal devices. So David's really answered that. We're talking about using our own phone or device. Make sure we put in place those compliant operator agreements. So for any time we're going to have an operator that's using covered information, we've got to have that agreement, and it's got to be listed and posted to the website. Being prepared for that data breach so that we know exactly what to do, both to prevent it and to respond. What's that step-by-step checklist if it were to occur? Protecting passwords, right? This goes beyond SOPA to just good practice, right? First of all, don't choose an easy password, and 2, protect it, right? I don't want to see that little post-it note of passwords right there on your monitor, right? Those are the big no-nos, particularly in a post-SOPA world. That would not be a reasonable security practice, in my view, whatsoever.
I actually had somebody tell me during we were investigating a certain piece of data, and they said, here, we were on the phone and said, here, just go to the page here, I'll give you the password. It's like, whoa, 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 stop. If you can just give it to me over the phone, one, it's probably not the most secure environment. If you haven't implemented two-step authentication, where there's a password plus a secondary device that's needed, again, that's my signal to you. This is my signal to you. You need to be talking to somebody with the expertise to know how to set all those things up. Two-step authentication is really important. Guys, even in our own office years ago, we had lots of breaches within Gmail, or potential breaches where somebody was trying to get in. Until we implemented two-step authentication. Since we implemented two-step authentication and everything, we don't ever have breaches on Gmail, knock on wood, because it requires the person to be sitting in front of their phone. If my secretary is trying to get into her email, she's going to have her phone with her, and that's really important. Again, this is going to go to our keys to the kingdom and making sure that not just one person is secured over everything. We'll talk about that in a couple of minutes.
Yeah, number 8 here in our top 10 list, nothing is free. As David said earlier, this is something that we need to invest in. This is not the time to just look for what's the easiest or the cheapest or the free. I mean, and that goes not just to our compliance here, but when we're downloading free apps or using free software, we're paying for that in some way. I mean, what makes a free Gmail account free? It's that they're getting to use our data to target advertising. What makes Facebook free is the targeted advertising. They're looking for our data. We're paying for those free things with the privacy, and that's not okay in the school context.
Particularly as the world moves dramatically, the amount of data breach that is occurring every day has gone dramatically up. The sophistication of those wishing to seek your data has gone dramatically up. And it's not just, I can't tell you how many cases I've had where you have some kid in Indiana who managed to hack the school system because he happened to either get the wrong address, if your school district sounded very similar to the school district down the road from him, or because he had a vendetta based on he was in school there 10 years ago, and he's upset and he hacks the school's software. Moreover, I had just a year ago a situation where a school district's entire software system got locked down by a foreign intrusion because they wanted money. It was ransom demand. And they locked down an entire school system because of it. So these are the kinds of things we've got to be really careful of. And remember that data is getting more and more and more sophisticated. 10 years ago, our website was effectively a Word document posted to the internet. Today, it's protected by about 15 different pieces of software. And we've got subscriptions on all those pieces of software because you'd think a little firm in Central Illinois is not a great target for ransomware. And you'd be wrong, because literally any address that's out there that's unprotected potentially has some value in it. And it just takes an extortionist to seek that value.
Number 9 here are those low-tech security issues, like somebody looking over your shoulder at Walmart or sharing devices with others. So we want to make sure that we're not thinking about some of those lower tech issues where data and information get shared as well. And then finally, we want to be careful about that one-person show. I mean, I think this is the give and take. Yes, we want a chief privacy officer. That's my recommendation. But if only one person is in charge, if only one person has the data, if only one person has the passwords, and they get sick, they get COVID, they quit, they turn to the dark side, that creates havoc for the school district. So we want to make sure that there is, as part of security, the shared responsibility with the right people to be able to make sure that our system is workable.
And an attorney that used to work with us some years ago said to me that I was working a breach of security case, and he said, your problem is you're looking for moral versus immoral. He said, that's not what causes a breach. Breach is caused by knowledge meets opportunity. He said, it's not a matter, he said, I'm not going to tell you there may not be a moral component, but you can't determine morality, because morality is in large measure defined by what you can't see, not what you can. It's knowledge plus opportunity. He said, the best way to preserve, this is actually a financial breach, not a data breach, but it was a really good lesson for me as a young attorney. He said, one of the best ways to prevent these kinds of opportunities is to shut them down. And that comes down to your two-step authentication, right? Like when our money's going out the door, don't you have 2 people sign the check before the check is spent? Don't you, when money comes in, just think about your ticket sales. Right? When you do ticket sales, not one person sitting there with a box, or at least I hope it's not. There are 2 people sitting there. One person takes the money, the other person counts the money, provides the change, and hands it back, right? We have 2 people. And at the end of the night, when we balance the drawer, and I hope we always have 2 people balancing the drawer, we have 2 people sign off on that. It prevents either from having the opportunity independently of the other, which cuts down on the number of potential breaches. The same thing, your data right now is your money. That is, and it's not your money. This isn't the business. This is the public's money. It's tax money that has come into the school district. And so what I think you need to be thinking about when you think about those procedures for security is, how do we have a 2-step authentication system of all data coming in and all data going out to assure that, one, there's one person who's responsible for overseeing it, but all data that comes in is back-checked twice, all data that goes out is back-checked twice, so that we assure that it's not one person with the keys to the kingdom. which means that if we're going to store passwords somewhere, like for instance, we're going to store passwords on a computer, if that data isn't encrypted, you've made a mistake. It needs to be encrypted. Encrypted doesn't just mean a password. Encrypted means that that data has to have a key on both ends that matches. And if you're not doing that, now's a great time to start to figure out how to get that in line, because encrypted data is very nearly impossible to steal. Not impossible, everything has a possibility, but at least in the event it's stolen, you're going to be able to point to, we took that reasonable security measure to assure that whatever data that we have that we are storing was fully protected.
So we've reached the point of some Q&A. And so we've got lots of good questions. So I want to jump in and start walking through those on a variety of fronts. I'm going to post again for everybody's benefit in the chat a link to the PowerPoint. I'm also going to post for everybody in the chat a link to a checklist that David and I created that hopefully is also a good resource for you to try and think about this visually and to be able to walk through that. Another good resource I would recommend, in part because we had a chance to review this ourselves, is the Illinois Council of School Attorneys through the School Board Association created an FAQ that I think is really well done, available on the IASB website. So that's also a document if you're looking for good resources out there, that's one that I would recommend. But I say, David, let's jump into our questions here.
Let's do it.
I'm going to start with some of them that got emailed to me ahead of time real quick, and then we'll jump to the ones that are here in the Q&A as well as in the chat. Question here, what if a company does not have a privacy policy that meets SOPA requirements, but they at least have a privacy policy? How do we make sure that that privacy policy meets the requirements?
I think it's a good question. I think that first of all, if we have a privacy policy that doesn't meet the SOPA requirements, we're going to have to work with that company in order to contract or at least insist upon an updated policy. And if they don't meet if they refuse to work with us, or if their policies don't meet the requirements, I don't think that we're going to be very safe continuing to use that company. I think the law technically prohibits our use of that policy on a going forward basis. Now, I don't want to be irrational about that, because I acknowledge to you that some of the companies are going to likely believe that they meet SOPA requirements and may not narrowly technically meet them, or at least not meet them in a way that makes us very comfortable. When that happens, that's going to become a risk calculus question for you. So I think you need to start with, does it comply? I think you need to move to, if it doesn't, will they agree to a contract for compliance? And then third, if you can't get to a contract agreement, then you're going to have to ask yourself, is it feasible to continue to work with them given their non-compliance, or is this a risk calculus situation that technically they don't perfectly comply, but generally speaking, yes, they do comply. I can defend it because ... I think that's what you're going to be looking at, is how much risk are you willing to accept given the company's non-compliance, and do you at least have an argument at that point that the company is demonstrably compliant with FERPA, COPA, and at least the intent of SOPA.
So we've got lots of questions about specific programs, and certainly, the intent today is not to sit here and walk through all these specific items and what their contracts provide. But I think generally speaking, when we think about that broad definition of who is an operator and what is covered information, it covers a lot of things. And so, a lot of questions exist here in the group about that. And so I just want to go back and make sure that we understand, that the definition of covered information is pretty broad. And frankly, I think it's more broad than the FERPA or student records definition. And so, question here, what is the most basic data element that would be considered identifiable. And I think that that can go back to, anything that we can tie back to a student, basically. And I think that that's through any form of cross-reference would do that. David, do you feel differently about that?
No, I don't. And I think that in answer to a number of these specific, without getting into any of the specific software pieces, I'm seeing a whole bunch of them here. I think the definition of operator is important here too. Operator means, out of the statute, to the extent that an entity is operating in this capacity, the operator of an internet website, online service, online application, mobile application, with actual knowledge that the site, service, or application is used primarily for K through 12 school purposes and was designed and marketed through K through 12 school purposes. In other words, if there's something that you're using that is an application or an internet provider or something that was designed for school use, Teacheries is a great example. I think Google Classroom is another great example. These are clearly designed for school purposes. If it is, then I think it meets the definition of operator. And I go more broadly than that, because I think that you may be tempted to say, well, in that case, because Google generally isn't marketed for K through 12 school purposes, therefore it can't be an operator. I think that relieves Google of the liability for compliance with SOPA if you're using the non-Google Classroom version. But I don't think it relieves you of liability for failing to use the Google Classroom covered provision and instead using the free one. I don't think that fixes the SOPA problem. The obligations on you are there. The core obligations are there regardless. The question is, did you shift some of that liability by utilizing one of those programs that's designed for this purpose? And if so, are they actually compliant?
I'm just going to start going through these in order, David. If we've got and I'm going to, in some of these questions, replace the name of a specific program more generically. If we use an online IEP software program, what if a parent requests that their child's information be removed from that website? And I think that this goes back to the right that parents have in terms of their ability to ask that their information be deleted from a website. But I think that that also comes back to, we also have a concurrent obligation to maintain those records under law. And so there's an exception if that maintenance is required by law. And if that's the way that we are maintaining that education record, then I think that is, that's how that would play out. Do you disagree?
Yeah, I don't think that we're required, for instance, to have a separate system of paper to back up all those electronic records that parents don't want to be a part of. On the other hand, I think the facts are going to matter there some, and I want to be careful about offering too broad an answer, because I do think that if a parent said, I don't want my kid listed on Facebook, I think under the FERPA regulations, set aside SOPA, FERPA says absolutely the parent doesn't have to have their, so yeah, if the parent doesn't want their kids' awards shown on Facebook, scratch that parent's kid is taken off Facebook. On the other hand, if we've got covered information that's through the district's website, generally speaking, I agree that the school district doesn't have to remove that if that's our sole method of storage. On the other hand, if we've had a breach of that particular type of software, if there was a broad-based breach and it was widely distributed that there were lots of student records compromised in this breach, I don't think it's necessarily unreasonable for parents to say, you know what, I don't want my kids' information in that system any longer. I think that I think the district is compelled at that point to evaluate whether security measures going forward are appropriate for continued maintenance within that system, or whether the school district needs to start to remove students from that system and put them through another system. But again, this is where it comes back to the policy and the understanding of the contract to know how we go about and what our rights are to tell the operator that they need to remove student data from their contracts, from their resources.
Next question, do we need SOPA contracts for state databases through ISB? No, there's an exception for that requirement for the State Board of Education. So for those types of programs, that is done. So for ISB's student information system or other things in ISB, that is taken care of. How wide is the definition of covered information? We've tried to indicate it's pretty broad. You know, the question here is a photo editing app. If it's using student, doesn't have their names, but may have the photo of a student. A photo of a student is covered information under the definitions. So,
without a question, student is individually identified.
Yeah, so if we're using photos of students, even if their name is not associated with it, I think that is covered information, and therefore SOPA does apply in that situation, and that we would follow all the requirements of SOPA in that regard. What about subs? Well, you know, I always say substitutes actually have more rights under FERPA and the Student Records Act than anybody else, because they can see personal notes without them being converted into education records. But ultimately, it comes back to that, I think, basic definition. And under, I think this is more of a FERPA question or a Student Records Act question than a SOPA question. Substitutes have a right to information to the extent that it's required for them educationally, right? So in order to meet the needs of students during the day they're there, they have a right to what they need to know in order to implement. And if that means they need to know what an IEP accommodation is or other things, if they're responsible for implementing it while they're there that day, then they have a right to that information. And so if we want to have them have the ability to access certain digital platforms, just like any other employee, I think that they can utilize our system, but we want to make sure that we've got the right login, permissions, and setup for them, just like we would for any other employee. Again, I think the most basic term, first name or last name, right, is within the definition. I'm going to look again here at the definitions to make sure that I'm reading that first and last name, biometric information, socioeconomic information, search activity, voice recordings, geolocation information is pretty broad. So when we're asking somebody to you know, register for something, even if they're not using their full name, I think we treat it that way. Do you disagree with that, David?
No, I wouldn't. I mean, again, I think the part of the problem here is we're identifying these at 50,000 feet is the lawsuit results primarily from something having happened. And what you can presume is if there's a lawsuit, covered information is not going to be, whether or not it was covered information, is not going to be a source of much of a defense, because the fact there's a lawsuit suggests it got out. So to my mind, the basic element is, the most basic element is any element you're putting in by which you know who the kid is. You know who the kid is, somebody else is likely to be able to figure that out as well in most instances.
So let's shift gears here a little bit and ask a real big question. So what if, for example, Google doesn't agree to a SOPA agreement by July 1? What do we do at that point? I mean, this goes back to your question earlier, David, about our bargaining power, right? With other entities, with smaller organizations, we probably got some more bargaining power to hold out. You know, I think with a behemoth like Google, our bargaining power is obviously much different. And at that point, you know, I think it's a risk analysis in terms of how close to SOPA's compliance their terms of agreement are. Because the reality is, I think we have a terms of agreement with them. The issue is whether they're SOPA compliant.
Yeah, as soon as you, in fact, when you agree to purchase that software or to work with that software, you're going to click a terms and conditions. that like 20-page long, single-spaced, 8-point font thing that nobody actually reads. Well, now's your time to read that thing to see if it actually is SOPA compliant. Again, one of the questions I might ask on Google is, how many of your neighbors are using Google? And assuming that everybody here is going to raise their hands, the likelihood, I mean, one of my best defenses in a case like this is, and how am I different from every single other person? If we're all doing the exact same thing, I do think that's a viable defense. Now, I don't want to tell you that that we're a bunch of lemmings and if we all jump off a bridge, that nobody's going to die. Yes, somebody's likely to get caught, but I acknowledge that if you're a smaller school district, you're a smaller target than, say, a large urban district with a lot of angry parents. So one thing I'd encourage you to do is to have an understanding of what all your neighbors are doing, and then go to the terms of service and ask yourself, when I click agree here, can I click agree? And if the answer is no, and again, this is a place where I think conversation with your neighbors is going to be important, because my suspicion is, before you even call us, when you talk to your neighbors, somebody's going to have thought of that issue. And you may discover before you even get to us a couple of things. You just narrow your focus a little bit. Hey, when you call Brandon, or you call me, or you call Chris or Jeff, one of the things you're going to be able to say is, hey, I've got this page in the terms of service, and I'm concerned that it doesn't meet SOPA here, because my neighbor called that out. What do I do? Now we can have an honest discussion with you about, here's what your calculated risk is. My suspicion is Illinois is a pretty large state, and Illinois probably has more remote learners this year than most states in the union. And as a function of that, because Illinois has had pretty assertive rules throughout this pandemic, as a function of that, my bet is that Google and Apple are paying attention. And my bet is their lawyers have created some pretty aggressive language. That aggressive language is going to protect Google. It's not going to protect you. But again, how much risk do you want to assume, particularly knowing that at the end of the day, Google's software is probably going to be better encrypted, better protected than most of the alternatives that are out there. And so you're going to have to ask yourself how much risk you're going to take on.
And again, I think that's the key between using just a Google platform and a Google for Education platform, gets you well on the way there.
Yes.
So to go back to some of the more public facing or social media related comments, even though Facebook, Twitter, and YouTube were not created specific to education, so they're not intended for K-12 use, are we suggesting that we get agreement? No, I'm suggesting that we don't use them for covered information. So like when we use our school Facebook page to recognize our students, picture of students who won a game, place at state, do something positive, I think that's where we're in the directory information versus public information piece, because SOPA doesn't apply to information that is publicly available. And I think that lines up with sort of the idea of directory information under the Student Records Act. So I think that we have the ability to share that information publicly, and use those types of social media sites when we're talking about that publicly available information that was directory information, unless, of course, and this is an important caveat, that the parent has opted out of directory information, right? Because parents have the right to opt out of that. Otherwise, I think you're okay. What I would not and never use a public facing platform like Facebook or Twitter or YouTube would be to send private information otherwise about students, because that is not a private communication. Just to take an example, if a teacher gets a Facebook message on Facebook Messenger from a parent about a specific student issue, they should never be using Facebook Messenger to communicate with a parent about a specific student issue. That is not going to be FERPA compliant. That's not going to be SOPA compliant. Because that conversation is being mined for data by Facebook. That's how they make money. So I am 100% okay with using those public-facing platforms for publicly available information, like honors and awards that would fall under the directory information exception. But I'm never using those types of platforms for sending otherwise confidential or covered information.
And I think that, I mean, I think this comes back to our sort of core, why are we doing this in the first place discussion is, just as Brandon said, Facebook, YouTube, Instagram, they're all TikTok, they mine data to make money. That's specifically how they make money. And one thing that I want to be really careful about is this is, I've been saying this for years. I know Brandon's been saying it as well, but I used to say, make sure that you're always sending it by email because email is trackable, email is protectable information. In the event we have an IEP process or some other lawsuit, we can search email and we can pull up all that data, even if it wasn't printed and put in the student's file, we still have the information that should be in the student's file. These days, one of the responses I get a whole bunch really frequently from folks is, look, I want, or we have teachers who have students whose parents don't read email or don't have email, but they'll check a text message. Well, there are apps that are designed for schools that save that are in fact FERPA compliant, that are ISRA compliant, that are COPA compliant, and that are likely to be SOPA compliant in the near future if they aren't already, that are apps that you ought to be using that do the same thing, that save that data. My own kids are in a school where when their teacher sends a message, that message goes to every type of communication we have. All her messages are sent through what is really an email service that she's using, but it's sent by text message to us. It's sent by email. It's sent by, we call it the wolf for anyone who's an Office fan. We call it the wolf. Every single potential option, there's a call where the digital voice reads it to us. They call us in many, many different ways, but it's all stored in one central location. Therefore, the data breach only happens as a function of that central location. And to the extent that that information is sent to devices that it's not supposed to go to, that strictly is a function of the parent's breach, right? And parents misinputted information, because I don't even get anything unless I put in information myself, not the teacher. The teacher doesn't input any data at all. I'm the one who inputs the data as to where that information is supposed to go.
So I think some big picture questions here about how far this reaches, right? Do we restrict the entire internet to our students? And I think that the recognition here is this does not apply to general audience websites. It's about where we are as a school asking them to use that platform to put their information in, to use that as covered information. And so I don't think that this means that we can't use the internet. I think the issue is, when are we putting information out there as opposed to getting information in, right? Which direction is that stream of data? And the difference between a general audience website and an operator that's intended to be used for K-12 use. And I think that's the key difference in what we're doing and what we're putting into it. And of course, when we're required to register for something, I think that's the key, right? The difference between a general audience website and something where we're going to have to register for it, right?
Yeah, or where we're specifically requiring students or parents to use a particular system for something, for access to data or for input of data. Anytime that they're sort of in this business of providing this information or this service, or anytime that we are specifically routing them through that information, and some of the things that come up to my mind that may not be quite as obvious as sort of our generalized storage data is when we use a third party for provision of information to colleges or something like that, or we use a third party for even something as innocuous as potentially yearbook, if yearbook is providing more than directory information, such as credit card information, by the way, or Social Security information. Those things do then become operators for purposes of the statute.
Yeah, so like the question was, what if students are doing research and using websites for the research? Unless they're putting covered information into that website, I don't think we have an issue, right? But if they're saying, put in my email address and I'm going to get something back, Maybe that now changes that to the extent it's being used.
But again, I mean, I also think that this comes down to our, I mean, forgive me for thinking like a defense attorney for a moment, but this comes down a little bit to our education of the students, because I can't prevent the students from putting covered information into a website, but I can educate them that they're not supposed to be doing that. And therefore, if I've educated them, that becomes my first defense. This was not a contractor that we were using. They're putting that information out, mom and dad. If mom and dad come and challenge us on it, look, we educated them. They weren't supposed to do this. It was the student that was deliberately indifferent to the rules, not us.
And I think the key here for SOPA purposes is we're talking about student data, not necessarily employee data. So a question here, does SOPA apply to programs that are not used for students, like teacher evaluation software? No, I don't think SOPA technically applies, but we have separate data privacy requirements that might go into effect there, right? Where we've got to keep those confidential and private. So we still want to make sure we're using reasonable security practices, even when SOPA may not be the statute that is governing at that moment in time.
Yeah, and I want to be careful there too for two reasons. First, 24-7 says that we're not allowed to, or 7A, I think, it says that we are not allowed to distribute evaluation data. So we're still required to keep that private, as Brandon said. But I think the secondary issue is that some evaluations I've read, particularly this last couple of years, I've seen a lot of really specific notes, and I've seen this a lot with special education classrooms, really specific notes as to individual data with regard to students. Incident by incident, specific explanation of what happened with the student's name and all that. This is a good reminder. I've always advised, I want a lot of facts, but not necessarily identifying information for a student. This is exactly why, because I think under an act like this, you're really vulnerable to an argument that, in fact, you've created covered information and thus the teaching software should have been SOPA compliant. Guys, it's a really end road around argument on something that doesn't need to be there. But I've had 2 lawsuits that were effectively whistleblower complaints on folks who were in trouble for other reasons, arguing failure to protect sufficient student records data. So again, a backdoor into a lawsuit to really challenge substantive issues. But to my mind, the best way to avoid that is don't create covered information. Don't talk about students specifically with identifiable information when we're talking about incidents where the focus is not the student, but really rather how the teacher handled that issue. So to avoid having to turn one of those evaluated software pieces into a SOPA compliant agreement, let's make sure our evaluators are evaluating in a way that is SOPA compliant by not creating covered information within the evaluation itself.
So David, if the terms and conditions state that the vendor says they're SOPA compliant, are we good to go? Do we just take their word for it and go from there?
It's a great question, and I think the answer is absolutely no. I think you're going to have to go deeper than that. I would love to simply believe that when somebody says I'm not a liar, it is so. Although my experience historically has been when somebody says I'm not a liar, usually there's a reason that they've told me that is true. When somebody says don't challenge me, usually there's a pretty good reason why they don't want me to challenge them, and that usually is the basis for the challenge. My advice to you is saying I'm SOPA compliant also raises the standard for me a little bit from a legal defense perspective. The minute they say they're SOPA compliant, if I just accept that, I think that case writes itself in terms of deliberate indifference to a known risk. It writes itself in terms of deliberate indifference to the rules. If you think about it for purposes of deposition, if I've got you under oath in a deposition, I ask you the question, how did you know that this company, how come you didn't know this company wasn't compliant? And your answer is, they told me they were compliant. You've acknowledged that you didn't do any deeper dig. So I'd advise you to go through and at least go through that checklist and ask yourself, and in the checklist, what you'll see is just on the website and policy, There are just, what do we put in, Brandon? 6 in the school website and 4 in the policy section, just to check to see that we've got these basic things set forth. If you at least did that, you're at least a few steps forward. And now if you look at your contract and say, well, I have no idea whether it actually says anything about collection, use, or disclosure of data, of covered information, at least you've given yourself something to go back and try and figure it out and narrowed your focus a little bit so that you're not spending. I recognize that part of your concern is you don't want to do a wide net cast where you're spending 47 hours looking through an agreement. But at least if you can check off a couple of boxes and say, well, I know this is covered, or I know this is covered, I know what liability is there in the event of a breach, that's literally just one checkbox under breach. I know what liability, whose liability is whose. If you've got that information in there, at least you're several steps forward, and then you're not answering in deposition. Yeah, I just took their word for it.
Yeah, and I think that those are relatively straightforward. Now, I guess if they say I'm SOPA compliant and I will take all the liability if I'm wrong, maybe I do that differently, but that's not going to be the way that contract is written, right?
I've seen a couple of agreements that said that, but they were offered by school districts, not by contractors.
Couple other questions. Does a special ed co-op need to provide separate annual notice to each parent of students served, or are we included in the district notice? Well, I mean, I think ultimately the issue here is that's a matter for the district and the co-op to figure that out, right? If the district is doing it and each student served gets the right notice, and it's accurate and meets all the requirements of the cooperative, I think that notice is sufficient. I don't think you would need to get it twice. But if there's something that's different between the two, then I think we would want to make sure we're doing that separately. But I think that there's no reason why, generally speaking, your notices can't be the same notice. All right, David, I'm going to scroll through here to see if we have some things there, some other questions that we
There's
have.
one here. Doesn't an ILNDPA, National Data Privacy Agreement, take care of making sure that we have a compliant contract rather than pouring over contracts with non-legal eyes? This comes back to that question of who's going to agree to the agreement. This is LTC recommends this agreement. There's an Illinois Alliance with a collaboration of school districts. I've looked over the agreement. Look, I love agreements that are drafted by our own organizations that are designed to be helpful to us. And if you can get anyone to agree to that agreement, without speaking to a particular draft of that agreement, watch out, there are multiple drafts of that agreement, some of which are pre-SOPA completion. So you better make sure you've got the right exhibits. You've got to make sure that you've got the right draft. You've got to make sure that you're looking at the right one for the data that you're using and the time we're in. But assuming you were using one that was well drafted, and I'm just going to presume for purposes of the question, you've got one that's well drafted. Yeah, that's great. The problem is you've got to get everybody to agree to it. And again, with your local contractor, with small contractors, my suspicion is you'll get those kinds of agreements. But there are lots of software companies that are not going to agree to an Illinois set forth agreement by a group that's working really on behalf of Illinois schools. In fact, for instance, Teacheries, I just Googled when the question came in, Teacheries has set forth here that while a customer can adopt an agreement on their own, they're not necessarily going to agree to your agreement in every instance, and they're going to want to write one of the exhibits themselves in the way they want it to read. And so that's going to limit you in terms of things like how much they're covered in terms of liability, whether they're liable, whether they're going to pick up some of that liability, or whether they're going to do some of the things for you in the event of a breach. One of the nice things about some of those agreements is they provide that the contractor is required for notification in the event of a breach. I would love that. If I could get that every time, that would be great. But my guess is not all contractors, see, for instance, Google, are going to agree to that level of notice and that they're going to be required to undertake that obligation. My guess is in a lot of those, you're going to be undertaking that obligation. They'll do sort of initial notice, but after that, the specific notices under the statute, you're going to have to do. And if they won't agree to that, then it doesn't just end the discovery for you. You're going to have to go just a little bit deeper, I'm afraid.
So, I want to go back to where we began, right? We want to try and just, cut to the chase in terms of simplicity here. And I think what we just need to make sure that we're all doing between now and July 1 is adopting our SOPA policy, getting on our website what needs to get on our website. And by doing that, we're going to get a bunch of that stuff taken care of, right? Because that's how we're going to inventory our operators and make sure that we've got those written agreements linked there. So adopt the policy, post to the website, and train folks up on those reasonable security practices. And probably number 4 would be have that data breach plan ready to go. And if you've done those 4 things, you're there, right? Now within that, there's some subcategories, right? Like I said, like adopt the policy, you've got some decisions to make about the policy, get this things posted to your website. That's going to take some work to make sure that we've got our compliant operator agreements that we can get there. And again, we're going to have to work on that over time and update that over time as we work through that. Train your staff on those reasonable security procedures and have your data breach plan. I think if we can do those 4 things, we're close enough to the goal line that we can all fill in the gaps and the details as we go forward.
And honestly, just this morning, I went and did just sort of a quick Google search on SOPA in school districts in Illinois, and I found a whole bunch of school districts already, including a number of clients of mine, that had already managed to get up on their webpage. Here's where our policy is. Here are all the software pieces we use. Here's a link to their pages about SOPA. And I thought that's a great start. It's not all the way there, but it's such a great start that we've already got links. We've already identified SOPA. We've identified Section 33 and that parents have rights. And this is where they go to a form to access their rights, to complain about something. Of course, they've got a section for breach, and there are exactly no breaches listed because there's none that have happened since July 1st, 2021, because we haven't gotten there yet. But I mean, these are districts that have already gotten sort of the basics checked off. And honestly, and I tell you that because if you haven't done that, if you haven't even started this process for yourself, I'd encourage you to go out and check that, because I think that it'll take down your blood pressure quite a bit, because it did mine when I did that and saw, wow, a whole bunch of folks that I work with pretty regularly have already done that. And I've had no conversation with them at all, because that tells me what they're finding is that sort of the basics of this are set forth in their policy already. They adopted the press policy. It told them to do a couple of things. They got some of those administrative procedures. They're going through those, getting those things up. And then once we get into the agreements themselves, one of them I saw was one that had sent me an agreement, a draft agreement they wanted me to review. Now we can start looking at sort of the nitty-gritty of these 4 or 5 pieces. Do these comply with SOPA? And if not, what's our risk calculus?
Yeah, so I think we're there. So again, it's I don't think it's a huge change what we're already doing outside of probably having to post on our website. And in my view, it's no change what we should have been doing all along from a data privacy standpoint, regardless. But now we're going to have this additional piece with the ability for it to be enforced. So we need to make sure that we're getting there. And I think just starting with those basic steps to get forward, we're going to get where we need to go. But thanks everybody for all your questions today. You know, it's always good to have everybody's interested in this topic and to try and put some information out there for everybody. So again, there are some great resources out there. through the LTC and ISB, and also, through the School Board Association and the Council of School Attorneys. Their FAQ document is also, I think, really, really helpful, and helps us all get really close to that. So, we've got to get prepared for understanding that data privacy is important. And I think that, again, as things have moved forward so fast with technology over the last year, it's important to make sure that now we're letting the data privacy piece catch up to us as we're doing so much more in an online and virtual world. So any final thoughts or comments, David?
No, I think we've pretty much covered it. I thank everybody for their attention. Thanks very much for coming today. And please do keep in mind as you're working through all this that, again, we've been protecting data for a really long time. This isn't really new to us. It's just a matter of being just a little bit more transparent with parents about where that data is being stored. It never concerns me to let parents know about rights that they already have. And so, to my mind, I mean, you guys in the special ed world are used to that daily. We've been dealing with that from time immemorial, as far as you and I are concerned, Brandon. And it doesn't necessarily increase the number of lawsuits. So don't be worried about the liability. Be worried about the communication at this point. I think that if you stay focused on that, I don't think it's too big a task at this point. So. Thank you.
I agree. And my guess is we'll maybe be getting back together here in a month or so to talk about all the fun things the General Assembly is going to do for us to talk about this spring. So that'll probably be the next time we get together, right, David?
Yep. Look forward to seeing everybody in person again sometime soon.
All right. Thanks, everybody.
Thank you. See ya.